Hey everybody, it is Alicia Abney,
And Brianna Lichardi.
and we're here today to talk about Title IX. Um, I know this is a topic that is often mentioned at universities, but we're going to really dive into it and really discuss Title IX in a way that you hopefully have never heard about before. So, hey, show of hands while you're at home. How many of you associate Title IX with sports? Okay, yeah.
I saw a few hands.
Okay, yeah, good showing. So, yeah, me too. And still to this day, even now knowing what I do know, I still associate Title IX with sports because that's where we hear about it most often. I've known about Pat Summitt, who was my hero and who I always wanted to play basketball for until I realized I was terrible. And I know her story of driving across the state with her team with personal vehicles and throwing out cots in the middle of the basketball court and sleeping because they didn't have the option that the men's team did. So, but Title IX is much more than just athletics, and we're going to discuss that. So, what is Title IX in its purest form? Um, Title IX states no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So, this is a federal civil rights law that prohibits discrimination on the basis of sex in any education program or activity that receives federal funding. It was signed into a law by President Richard Nixon on June 23rd, 1972. The founding mothers, that we will talk about, of Title IX just wanted a more level playing field in academics um, with the men. The true significance of Title IX has been the accompanying increase in opportunities for women off the field, a level of female empowerment so strong that Bernice Sandler calls the law the most important step for gender equality since the 19th Amendment gave us the right to vote. So, those of you that are, this is just a bit of a side note. So, those of you that are preparing for comps or know that you will have to take comps, if you by any chance have to talk about or write about a significant person in higher education, that would be Bernie Sandler. So go ahead and jot that down if you will be taking comps because you will want to know this. All right, so Bernice Sandler. She's known as the mother of Title IX, the godmother of Title IX. Basically, she's the one that did it. So she was a part-time lecturer of educational counseling at the University of Maryland, and again, she's a lecturer, so she sees this position open for a tenure track. There's a tenure track position that opens. And she was like, okay, I meet all of the qualifications for it. I'm ready for this position. And of course, she wants to move up in her field. That's what she's worked for all of her life. So she applies for it. She goes through the entire application process and she's denied the position. She's not denied for any reason or any of her qualifications or her recommendations. She was denied because she, quote, came on too strong for a woman. No, that did not work for her. So after this happened, and she was very angry. So she went and started researching laws on gender discrimination. And she found this footnote to a law on federal contracts that prohibited discrimination based on sex. This was Executive Order 11246, amended by President Johnson, effective October 13th, 1968. It prohibited federal contractors from discrimination in employment on the basis of race, color, religion, and national origin. But then the amendment included discrimination based on sex. And again, it was this tiny little footnote. So she gets in touch with this guy named Vincent Macaluso. I know I butchered that. Maybe. I don't know. He was the assistant director in the compliance division at the Department of Labor, and he had been waiting on someone to ask about gender bias in academia. He helped Sandler craft a complaint against University of Maryland based on this little-known law. Sandler, after running an ad in the Sunday Review of Books, compiled 250 complaints against colleges receiving federal contracts. At the urging of Macaluso, she sent copies of the complaints to members of Congress, asking them to urge the Secretary of Labor to enforce the law. Because of this, on January 31st, 1970, the Women's Equity Action League, WEAL, filed a historic class action complaint against all universities and colleges in the country with specific charges against the University of Maryland. The charges were filed with the U.S. Department of Labor under Executive Order 11246 as amended and asked for an immediate compliance review of all institutions holding federal contracts. Until that time, the executive order had been used almost exclusively in cases concerning blue-collar workers, and although the order had covered sex discrimination since October 1968, there had been virtually no enforcement by the government until WEAL began its campaign. So the WEAL asked for investigation in the following areas. They wanted them to look into admission quotas to undergraduate and graduate schools, financial assistance, hiring practices, and promotions and salary differentials. So 200 copies of the 80-page complaint were sent to the press, select members of Congress with handwritten notes requesting they contact the Secretary of Labor, asking him to enforce his own regulations governing the executive order. They wanted him to do this by investigating educational institutions holding federal contracts to ensure there was no sex discrimination and to keep the members informed of the progress of the investigations. Once word got out about this and females in education realized they could report without divulging their names, Sandler was able to find more tangible data. She writes, many departments had no women at all, even though women obtained as many as 25% of doctorates in those specific fields. She said the pattern was clear. The higher the rank, the fewer the women. The more prestigious the field, the department, or institution, the fewer the women. At the administrative ranks, women were a rarity. At that time, even many women's colleges were headed by men. So then on March 9th, 1970, Representative Martha Griffiths, who was on WEAL's National Advisory Board, gave the first speech in the U.S. Congress on discrimination against women in education, based in large measure on information provided by Sandler. She criticized the government for not enforcing its own regulations with regard to sex discrimination in universities and colleges. Her speech, the barrage of congressional letters to the Secretaries of Labor and Health, Education and Welfare, and the numerous meetings women's organizations such as WEAL and National Organization for Women had with the Departments of Labor and Health, Education and Welfare paid off. The first contract compliance investigation began at Harvard University. In June 1970, the Department of Labor issued its long-awaited sex discrimination guidelines for federal contractors, and the Health, Education, and Welfare issued a memorandum to all field personnel to routinely include sex discrimination in all contract compliance investigations. They also hired its first female compliance investigator. Edith Green, like Macaluso, had been waiting for a chance to introduce a bill requiring gender equity in education. She had long been aware of sex discrimination in higher education and lack of coverage by civil rights laws. Green was a Democratic representative from Portland, Oregon, and also chair of the House Committee on Education. She was also a former teacher and a daughter of school teachers. She had been urged to hold hearings, but was hesitant to do so because there was little data available and apparently no constituency whom she could count on to testify. There were virtually no books and only a few articles that addressed the issue of discrimination against women in education. No conferences had been held to examine the issue. There was little research or data. There were no campus commissions on the status of women, and only a few institutions had even begun to examine the status of women on their campuses. The Congresswoman held hearings that few of her male colleagues bothered to attend, so she hired Sandler to work on her staff. Together, they drafted Title IX. Sandler writes, it's really just a variation of Title VI of the Civil Rights Act of 1964. Instead of race, color, or national origin, we substituted sex. From June to July 1970, the first congressional hearings on education and employment of women took place, and this is the official beginning of the bill that eventually became Title IX. The original bill is part of a larger measure on higher education proposed to amend Title VII of the Civil Rights Act to cover employees in educational institutions, Title VI to cover sex discrimination in federally assisted programs, and the Equal Pay Act to cover executives, administrators, and professionals. There were 7 days of hearings that resulted in a 2-volume set of nearly 1,300 pages. Sandler writes, the hearings probably did more than anything else to make sex discrimination in education a legitimate issue. When administrators or faculty members would deny existence of sex discrimination in academia, women and men could point out that this was not a frivolous issue and that Congress itself had held days of hearings on this important subject. So the hearings, as well as the continuing filings of charges against institutions under the executive order, gave women throughout academia hope and courage to become advocates for women and change within their institution. Higher education itself, even before the passage of Title IX, began to acknowledge that there was some validity to the issue, and numerous institutions appointed committees to study the problem and develop recommendations for their campuses. Not surprisingly, only a few committee members made short token appearances. Federal officials testified they supported the aim of the bill, but not the bill in its present form. A euphemism for opposition, pretty much. Then Representative Shirley Chisholm from New York testified that during her entire political history, her sex had been a, quote, far greater handicap than her skin pigmentation. Other African American women and female members of Congress also testified in support of the bill. Much of the testimony dealt with the employment of women both in and outside higher education. There was some testimony, but not much, about women students, mainly focusing on admissions and counseling. So this is interesting. So when bills are being announced and there's this huge lobbying effort to get knowledge about the bill out so that they can gain support and switch, certain Congress, their ideas to get them to vote on it. Representative Green actually discouraged any lobbying efforts for the bill because there was no opposition to the bill at the current time. And she said the less that people knew about the bill, the better its chances were of passing. Everyone was kind of skeptical by this, but Green was right. In the spring of 1972, 2 years after the hearings, a portion of Representative Green's bill became a law when Title VII of the Civil Rights Act was amended by Congress in a separate action to cover all employees in educational institutions. Initially, Representative Green had also sought to amend the Title VI. She had sought to amend Title VI of the Civil Rights Act, prohibiting discrimination on the basis of race, color, and national origin in all federally funded activities to include sex discrimination. But at the urging of African American leaders and others who were worried that opening Title VI for amendment could weaken its coverage, she proposed a separate and new title, which became Title IX. In its final form, Title IX was identical to that of Title VI, except that it was restricted to educational activities, contained additional exemptions, and included the amendment to the Equal Pay Act. On June 23, 1972, Title IX of the Education Amendments of 1972 was passed by Congress, and on July 1st was signed into law by President Richard Nixon. It would be 3 years before the regulation for Title IX to be issued, and then another year before it would take effect. And then from that, I just really like this quote. It reads, "And they shall beat their pots and pans into printing presses, and weave their cloth into protest banners. Nations of women shall lift up their voices with other women, neither shall they accept discrimination anymore." So now that we know what Title IX is and how it came to be, what came from it? So how did Title IX get from where it started to where it is now? And keep in mind that our original group had a third member, and obviously with the third, that had a third section, and we've omitted a few of her things. So bear with us as we jump around with dates and such. We did eliminate a section discussing the Clery Act, so kind of just going to assume that you know what that is because we're going to refer to it a little bit here and there. So the first thing that we'll talk about is the Violence Against Women Act. This was an act authorized and signed by President Clinton in 1994. This was the first federal legislation specifically aimed at victims of domestic violence. So this is where we're getting into Violence Against Women Act, the Violence Against Women Act, and focusing on how Title IX can be used for that. And this established the Office on Violence Against Women, the OVW, within the Department of Justice. So that, and then the Campus Save Act. The Campus Save Act expands the scope in terms of reporting, response, and prevention education requirements around rape, domestic violence, dating violence, sexual assault, and stalking. It refers to amendments to the Clery Act. As such, compliance will be determined and enforced by the Department of Education's Clery Act Compliance Division. Penalties for non-compliance with the Clery Act include fines up to $35,000 per violation and loss of eligibility for federal student aid programs. Another thing that took place was the Campus Climate Surveys in 2015. The Association of American Universities released the overall results of a survey that asked students at 27 universities about their experiences with sexual assault and sexual misconduct. The study was designed to meet all state and federal requirements for the conduct of sexual assault surveys, to provide a scientifically accurate survey instrument to help schools learn about the campus climate concerning sexual misconduct, provide a benchmark tool to allow institutions to compare their results against other participating institutions. But the overall response rate to this survey was 19%. So AAU noted that the low response rates were only an indirect indicator of the reliability of the results. They found evidence that their estimates of sexual assaults may have been biased upward because respondents were more likely to have been assaulted than non-respondents. And then the results of the study read that more than 20% of females said that they were victims of non-consensual sexual assault since entering college. 20%. Another thing is mandated reporting. So those of you that work on campus, Brianna and I are both advisors. We are both mandated reporters. So that means if a student comes to us and says, hey, this happened, this sexual assault took place, we have to report it. We have to contact the Office of Compliance and let them know what happened. So mandated reporters it's a responsible employee that must report any instance of sexual harassment, and no such thing is said in confidence. So when students come to me and they're talking about this is going on in class and they want to keep this between me and you, yeah, we can do that. But if they come to us and say, this sexual assault happened, we have to report it. It's not said in confidence. We tell them, we do have to say anything. So it's not between just me and that student. Um, and so I think it was made with good intentions, but it's not that great sometimes. So about 1 in 5 students, almost 1 in 5 students in a survey said reporting requirements decrease their likelihood of disclosing sexual violence incident because they want to go tell somebody that they trust what happened, but they don't necessarily want it to be reported. They just want to get it off the chest. Confidential employees have the privilege of not reporting, but are expected to offer resources to the victim. So MTSU's confidential employees include Amy Dean, who is the sexual assault advocate, also counseling services, counseling and psychological services, and health services on campus are also confidential employees. So why would a student not report? Well, I mean, they may be uncertain if a crime was actually committed. They know that something happened that made them feel very uncomfortable, or they're second guessing what happened. So they're not really sure if something did happen, or they believe it was not serious enough to report. Again, they know they felt uncomfortable. They know something wasn't right, so they're not sure. And a lot of this comes because a lot of sexual assaults have alcohol or drugs involved. So students don't want to go to somebody and say, hey, this took place, and I was also drunk. But it's good to know that universities will not pursue any disciplinary violations against the victim or witness for the improper use of alcohol or drugs. So it's important that students know that they can always come forward with something that happened and they will not get in trouble for alcohol or drug use that, if they were under the influence when it happened. Students they fear the loss of privacy. There's that feeling of shame, and then they may have to, they'll have to testify to police, go through a rape kit, or go through a college disciplinary hearing. And those disciplinary hearings are often made of a group of their peers. And if you're sick of hearing me speak by now, here is Miss Brianna.
Okay, so something a little more recent that came out of the Title IX enactment was the Dear Colleagues letter. Now there are a lot of Dear Colleagues letter, but there's one that's been made very popular recently. In general, a Dear Colleagues letter, or a DCL, is sent by a legislative member to his or her fellow members seeking to influence policy or practice. This letter begins with a discussion of Title IX requirements related to student-on-student sexual harassment, including sexual violence, and explains the school's responsibility to take immediate and effective steps to end sexual harassment and sexual violence. So we have the very beginning of the letter here on the screen for you to read, and it begins, "Dear colleague, education has long been recognized as the great equalizer in America. The U.S. Department of Education and its Office for Civil Rights believe that providing all students with an educational environment free from discrimination is extremely important. The sexual harassment of students, including sexual violence, interferes with students' rights to receive an education free from discrimination, and in the case of sexual violence, is a crime." So this letter concludes by discussing proactive efforts the schools should take to prevent sexual harassment and violence on their campuses. And it also provides examples of remedies schools and the OCR can use to end such conduct, prevent reoccurrence, and address its impacts. Another thing it addresses is to make sure schools are aware that accusers are allowed to appeal any non-guilty findings of the university. So the letter did lead to a lot of public support and public cries from students, staff, faculty. Students supported it because they were facing hostile environments on campus after reporting. In fact, several universities were put under investigation by the Department of Education due to their handlings of Title IX cases. Several universities were privately sued. Of those, some settled out of court. One example I found was in 2008, Arizona State University expelled an athlete for raping another, but then readmitted him, and then he raped another student. So ASU settled upon the agreement that they'd revise their practices moving forward. Other universities were actually found guilty in federal court. One example was the 2006 case. University of Colorado was found to have acted with deliberate indifference to those students who were found to be raped on their campuses. So what inspired the publication of this letter? Well, there were a few things. The first one was the 2007 report that was prepared by the National Institute of Justice called the Campus Sexual Assault Study. The report found that 1 in 5 women are victims of completed or attempted sexual assault while in college, which goes back to that climate survey that found 20%, 1 in 5, reported that they had unwanted sexual contact in school. The letter conveys request for action, which ties into findings from the Clery Act, which obligates universities to upload and publicize data of any offenses reported. The Clery Act found that nearly 3,300 forcible sex offenses had been reported in that year alone. So the objective of the DCL was to force schools to become more aggressive about sexual assault reports because that seemingly wasn't happening. In 2011, the letter was published to address these issues within educational institutions. And as you can see, and very, very quickly, it had an impact. You can see the amount of reported cases across the board increasing, from sexual assault to stalking. This is one of the improvements that was seen after the DCL was published. About 4 times as many reports occurred in 2017 as in 2012. An example of this, just to illuminate that, is that in 2014 the OCR had 130 cases versus in 2017 they had 400 new and open cases. And then I just checked it last month, the OCR had 197 resolved cases and 305 open cases still pending. Another key finding from the data was obtained by Outside the Lines. Awareness and use of Title IX offices has increased dramatically over the past 6 years, is what they found, and what the previous graph shows. And a leading force of this is that many coordinators and industry experts are citing high-profile athletic cases, making this more public. There are some concerns about the DCL, though, that we do want to address. It's crucial that members of the body who are responsible for overseeing these complaints have to have appropriate training and experience when handling them. So one of the key concerns was that there wasn't enough unified training, and yet they were demanding on some campuses an entire restructuring of the way that their programming ran. There was concerns that the accused were kind of left without a lot of rights, that there wasn't enough due process. And then a lot of schools were so worried about these fines and still unclear about what they were supposed to do, so there was some overreaction on campuses. Title IX requires that every recipient of federal funding designate at least one employee who's responsible for coordinating the school's compliance. So it's important to note that the letter prompted a lot of university responsibility and consequences for not following those orders. While it did clarify necessities for the responsible employee, a lot of Title IX coordinators didn't have the support, guidance, and training on their campuses that they needed to follow these guidelines. So a lot of the worst Title IX violations will occur when the Title IX coordinator doesn't have the necessary training or even the authority given to them on their campus in order to oversee their compliances. And just to preface that last concern about training, there are nonprofit entities out there like the Gender Equity and Education Act that provide Title IX coordinators resources, training, and technical assistance to ensure that there's equitable education across the country. So all of that work that the letter strove to accomplish has recently been kind of upheaved. In 2017, the new U.S. Secretary of Education, Betsy DeVos, began the cancellation of all of its guidelines that had urged colleges and universities to be more aggressive when they're investigating campus sexual assaults. Some of the new proposed guidelines are the narrowing of sexual misconduct's definition. The definition was narrowed to be only those instances that were sufficiently serious enough that it interferes with or limits the student's ability to participate in or benefit from the school's program. It also required proceedings to include cross-examination for the student who was accused. It no longer mandates a preponderance of evidence, which also means something was more likely to happen than not. And so now that means that universities can choose the clear and convincing evidence standard that is used in courts. And then lastly, the OCR, which had been providing the amount of assaults and keeping track of kind of where they stand with closing of cases, is no longer required to publicly disclose details of those investigations. So while these amendments have yet to be implemented, they've already been approved, and they were supposed to have been implemented in fall of 2019, but when I checked a few weeks ago, nothing had been set in stone yet. There have been positive and negative reactions to these amendments. So what I did was I found a quote from someone reputable that kind of generalizes the side of those for and those against these amendments. So the people who are against the DeVos amendments are so because they feel like they discourage victims. So this quote is taken from Brenda Adams, who's a senior attorney for the Equal Rights Advocates Group. She writes, "One of the problems with the proposed regulations is that it essentially leaves it up to the individual schools to determine what standard they want to use, as long as they use the same standard sort of across the board with all of their conduct rules. So that means that a school could choose to apply the much higher standard of clear and convincing evidence, which would of course significantly impact things for survivors." The body of people who are for these amendments are in general for it because they feel like the amendments provide balanced fairness to both the accused and the accuser that had been previously lacking. So this quote is taken from Laura Bezzalone, who's a law professor at the University of San Francisco, and she writes, "What I'm saying, and what I think these regulations are saying, is that they're just putting into statute what courts are demanding, which is fundamental, basic due process." So, with all of that said, with all that we know now about Title IX, what's working and what's not working? Upwards of 80% of college victims are still not reporting their assaults, as found by a study in 2018. Another study in 2015 found that the prevalence of unacknowledged rape seems highest among college students, and it is explained to be because of sexual victimization patterns, like blaming the experiences on alcohol, bad sex, or miscommunication. So, pulling a quote from our godmother of Title IX, I thought this would help us transition to the what's not working and the recommendations. She says, "Life has improved enormously since Title IX, but there are still pockets that need significant work." So what's not working? The dangerous culture inherent in male athletic programs. According to the Outside the Lines analysis of the total Title IX complaints collected for their study, college athletes were named as the perpetrator in 6.3%, even though they only made up 1.7% of the total student population. And this has been a statistical fact for decades. In 1995, for example, a very similar study found that athletes were named the perpetrator in 5.5% of assaults, even though they only made up 3.8% of the male student population. And for those of you who don't know, Outside the Lines is an American television program on ESPN that examines critical issues in mostly American sports. And this is also important because a sexual assault allegation against a student athlete, if convicted, will result in immediate suspension from the school and from the team. So this suspension has an impact on the student athlete's eligibility and the competitiveness of the institution's sports program. So the example I have on the screen from West Virginia is just one of the dozens that they include in this study. We've included the link to the study at the end of the slide, so I definitely encourage all of you who are interested in this topic to read on it. But at West Virginia, for example, their athletes made up less than 2% of the entire student body, and yet were named in 13% of the Title IX complaints that had been filed over the past 6 years. So why is the male athletic culture so dangerous when it comes to sexual violence, particularly against women? This was, again, another study from OTL and ESPN, taken from a report called "College Athletes 3 Times More Likely to be Named in Title IX Sexual Misconduct Complaints." This was published in November of 2018, and when asked this question, why is male athletic culture dangerous when it comes to sexual assault, they asked it to Title IX administrators across the country who worked with student athletes, and these were some of their responses. One said the hypersexualized culture associated with elite athletes, the aggressive kind of training and inclination that programs place on athletes to exert aggressive behavior. Student athletes probably have more sex than students who are not athletes, and it becomes more difficult for them to separate out what non-consent looks like because everything for them tends to seem consensual, aka they're not used to hearing no. Recruitment strategies that promote sex. One example provided in the article was Louisville, who provided access to strippers for recruits and used female students as hosts, attractive female students. And the trend of using sex as a bonding activity. Examples were Boys Will Be Boys, locker room talk, and a higher rate of gang rape and videotaping of sexual abuse allegations. I also found a USA Today study that was published in 2019, the following year, that claimed that 1 of every 12 names on the list of sexual allegations belong to an NCAA athlete, even though their ratio of enrolled students at the schools during that time were 3 times fewer. So only 1 in 36 students were an athlete, and yet they made up and yet 1 in every 12 had been accused of sexual assault. So 47 athletes appeared on this list. Nearly 2/3 of them played football. Their representation among disciplined students was more than 8 times higher than non-football players. And of these convicted students, at least 11 after their conviction and suspension transferred and were able to continue playing their careers at other NCAA schools. So that's a good place to lead into, well, what do we do from here? How can we move forward and make positive changes? So these are just some of the recommendations that Alicia and I have come up with. And to lead into the first one, I have a quote here from Lisa Fedina, who works for the National Institute of Justice. She writes, "College students experience different forms of sexual victimization. Treatment responses as well as campus responses to victims should be related to the types of sexual victimization experienced by students." So Title IX delivers very vague general guidelines with yet very specific consequences. Despite all of that, it's still up to the university to get to decide their consent, education, and prevention policy strategies on campus. So because of this, many policies are written to protect the university and not necessarily written to protect the student, which leads to policy that isn't understanding of the true nature of harassment or the comprehension of the student. Therefore, recommendation number 1, education needs to focus on correcting a violent culture, on the potential perpetrators, and not by putting onus on potential victims to be responsible to keep themselves safe. So this quote is taken from Pamela Jacobs, who's an attorney and an advocate. She says, think about it. If all women learn these messages, as in stay safe, don't walk home alone, don't go out drinking by yourself, don't wear short skirts, messages like that. If all women learn these messages from an early age, and we all do, yet half of all women are still being sexually assaulted, clearly something isn't working, right? So, how do we reframe our education? Well, we should be practicing culturally sensitive and inclusive programming. So these are 3 ways that we can do that. First of all, prevention education should be diverse. Trainings that don't include minority groups can be detrimental to those minorities' well-being and safety. For example, the number of students with autism diagnoses on campus is growing, according to a study in 2018. Research shows that students on the autism spectrum disorder are more likely to engage in stalking behaviors than other students because their comprehension of appropriate social behavior isn't intuitive. However, those same social naiveties, so to say, also make them more vulnerable to sexual harassment because they're not going to be as inclined to spot dangerous or manipulative behaviors of perpetrators. So this is a quote from that same study by Williams. The study was called The Nexus of Autism in Title IX. It says, asking a student with a communication disorder to interpret subtle or even not so subtle signals is akin to expecting a student with a visual impairment to read a no entry sign and then faulting the student for walking through it. So when we have trainings, we need to make sure that we are meeting all of these students so that they can walk away actually understanding what they need to. So examples of non-inclusive formats include programs that utilize humorous videos to teach, or just very large group presentations that don't allow for students to ask questions or to practice. Online tutorials, very implicit ideas. These are not going to reach necessarily students with ASD. And this is important because students with behavioral disorders aren't exempt from Title IX responsibilities and yet are still more at risk of misunderstanding their responsibilities. So it's important to make sure they retain the information necessary to keep themselves safe and aware. So some inclusive formats would be role-playing, small group settings that allow for questionings, one-on-one programming, things like that. Another suggestion would be to have tailored education. There are certain types of students who are more at risk of targeted violence, and there are certain types who are more at risk of perpetrating violence. For these reasons, there should be education and prevention targeted to these groups and tailored to their cultural awarenesses and experiences. One example, the National Center for Transgender Equality found that 25% of college students who are out or perceived as transgender are being harassed on campus. And of those 1 in 4, 16% drop out eventually. Another example, fraternity and male student athletes are more likely to commit rape, 3 times more likely, in fact. So by tailoring programs to these at-risk groups, we can adjust their unique needs. One example in regards to the fraternity and athlete groups. There is prevention programs aimed at men. One in particular that's been proven successful is called the Men's Program, which is designed to reduce men's defensiveness while still targeting their rape supportive behaviors and beliefs, increasing their empathy for victims, and including bystander intervention training. One that in particular, a resource provided for Greek life is a website, endrapeoncampus.org/Greek-life, which includes resources and suggestions for campus-based education for those particular groups. Lastly, we need to refocus refocus our programming so that we're not supporting the rape myth. And for those of you who don't know, the rape myth is the theory that women are responsible for and can therefore control their own safety. That women are secretly asking for it, or that rapes are only perpetrated by strangers and not someone you know and trust. So when we are reinforcing victim blaming and rape myth, when we tell the victim, this is what you should be doing to keep yourself safe, rather than focusing on the people who are committing these acts and figuring out how to reach them to change the way they are. So how do you do that? Another recommendation, make sure that your prevention programs ask the big questions to inform the way that you practice. So prevention and consent education should be both intentional and based on research. What predicts harassment, for example? Well, perpetrators are likely to be repeat offenders, a study by Fulbert found. Fulbert says, with an average of at least 5 infractions per perpetrator, chances are if a perpetrator is caught, he has committed sexual assault before and will likely do it again. Another predictor is male-dominated environments and organizational climates, aka male-dominated cultures, increase the likelihood and predicts harassment, because potential harassers are more likely to act out more in those cultures that they see that kind of behavior being permissive. And the university has unfortunately had a reputation to be a permissive place. What is hookup culture? Does it impact the way that students understand consent? These are important questions. Hookup culture is one that encourages ambiguous treatment of sexual partners and discourages empathy, connection, and communication during sex. We need to understand that this is a culture we are up against when we are teaching consent. So therefore, teaching consent as teaching sex as something that is communicative will be essential for their understanding. They need to see consent as equal to social justice, because if sex is consensual, that means both partners have rights, both are being treated as humans, and both are being respected. So there's been surveys about what students are thriving with the hookup culture, which are against it, which are ambiguous to it. and it found that 25% of students thrive in the hookup culture, enjoy it, adapt well to its rules that call for fun and casual encounters. A third of the students find the hookup culture to be unappealing and would rather avoid sex than have it in the way this culture mandates. And the remaining students are ambivalent to it. So overall, this survey found that 1 in 3 students say their intimate relationships have been traumatic or disappointing based on the hookup culture. And 1 in 10 of them say that they were sexually coerced or assaulted in the past year. And this was published in 2017. So we need to keep this in mind when we're writing policy, and keeping the students in mind rather than the lawyers, for the sake of their understanding. So current consent policies tend to assume students know exactly what they want in sexual encounters, tends to ignore social gender scripts like what women experience, the pressures they face, versus men and their pressures. It tends to leave students unprepared for how to use this policy in the real world. Policy can be very lengthy and verbose, and yet never specific enough to seem of value for students, which result in they become distant from it. They don't feel comfortable asking questions or trying to interpret the policy. And this is because, according to Freitas, who wrote Consent on Campus, a manifesto, washing our hands of sexual ethics, that's what she calls it. And when we do that, we're doing it because, quote, we are uncomfortable talking about values, and that leaves young people to fend for themselves. So she argues that consent is more than learning to hear yes and no. It's learning to pay attention to care for your partner's physical and emotional well-being. For example, alcohol. A lot of policy and education is focused on anti-drinking as a way to correct college sexual assaults. But just because alcohol is involved in college sexual assaults doesn't mean that policy resolving that issue will resolve sexual assaults. And that's because they're not asking those big critical questions. For example, another one, why sexual activity and excessive drinking go hand in hand? Or another one, why certain gender scripts, like women have to be gatekeepers of sex and men get to be single-minded and pushy about sex, affect the way that they view themselves and the way that they view sex. When you're asking questions like this that strike at the students' core values, you get them to question stereotypes, gender norms, and dangerous behaviors that they might have previously accepted already. Toxic masculinity can be weakened, especially when male students are encouraged to think critically about their perspective on sexual violence, and encouraging them to take a greater responsibility when education programs teach them how to, education programs like bystander intervention. So that is what we have. There are 2 slides of all of the works that we used in this project.
If you want us to post this, we are happy to do so. If you want any of these resources, we can give you those. If you want us to share our notes, we can do that as well, because we know this is a lengthy presentation. If you made it this far, thank you. We appreciate you.
Your prize is in the mail.
Yeah, somewhere. So yes, thank you.
Yes, and if you haven't already looked at them, we have discussion questions posted in D2L for you all to build your discussion amongst yourselves.
So thank you, and happy social distancing. Bye.
Bye.